Shira Truitt of the Truitt Law Firm. You have spent many years preparing yourself for the work that you do. One of the areas that you do focus on is estate planning. What is estate planning? Start there. Describe what a person needs to understand if they are preparing to address that for their family.
Estate planning is simply a way to order your life after death. It's simply a way to make sure that all of your matters from the time that you transition this earth are taken care of. And it's a way to make sure that things are ordered in a manner that you like during a time that you cannot make a decision for yourself. It is that simple.
That means your finances, your education, your children.
That means your finances, so that if something were to happen where you could not make a decision for yourself, estate planning through a power of attorney would allow you to designate someone to make decisions for you at a point where you're alive but unable, for whatever reason, to make a decision for yourself. An estate plan also is a part of a will. So wills are included in that. That just orders your property such that when you transition this earthly life, you know exactly what's supposed to happen, and the people around you know what's supposed to happen. So everybody knows what's supposed to happen, and when you transition, then people know what to do.
People are afraid to do that, though. I don't want to talk about what's going to happen to me when I'm gone, or what's going to happen to my property and those things that are important to me. Am I right, or is that an incorrect assumption?
That's common. That's a common assumption. But let me tell you something. You have an estate plan. Everybody in this state, everybody in the 50 states has an estate plan. Because if you don't make one, the state in which you live will make one for you. If you want to order your own estate, if you want to order your own property, then you have to make one that is separate. So if you want things to go a particular way, then you have to take control and do it. If you don't, then the state definitely has one for you.
Okay, I'm thinking about myself. I have some paintings that were limited edition. I have a house, I have a car, I have TV, some jewelry that may be of value. I also have a couple of credit cards that are outstanding. What happens with all of that? I mean, are those the things that you're talking about?
Those and so much more. When you have things, especially sentimental jewelry, like a mother's wedding ring, that you want to go to a particular person or to remain in your family, you may want to give it to a daughter, or you may want to give it to a son so that he gives it to who he believes he will marry.
Okay.
But you have to say that, or they will have to guess it. And what you want to do is be the one who allows that to happen, rather than to leave people to guess what you might want. If they can't agree, things get a little bit expensive. So then we have to sell the ring and get the money for it, and then split the money between the two. Sell the house and get the money for it and split the money between the two, because cash is a liquid thing. And that may be what you want, but it may not be what you want. The point of an estate plan is that you get to decide what that is.
Then I have to go through all of my property and list everything and have a true understanding of what I want to do then, is what you're saying. I have to be thinking about this.
You do. And if you don't, that's okay. The state of Missouri definitely has one for you. But if it's something that you want, so the paintings that you mentioned, you may want them to go to a particular person. For example, if they depict a particular thing like a sorority life or a particular organization in which you are in, you may want them to go to particular people. They also may have more sentimental value than they have monetary value. So you have to decide that, but part of an estate plan is for you to know and have an orderly understanding of what your estate is. Doesn't have to be a big estate. It doesn't have to be millions. It could be hundreds, but it's what you want. The whole point of it is to give you what you want, and things go the way that you want them to go, much like they do now. You control what you own. You give to whom you want, and you choose how you want things to go. An estate plan simply allows that to happen.
What's the living will?
That is an opportunity for you to give people information about how you want things when you are in a situation where you are alive but cannot make a decision. So that could be because you have Alzheimer's. That could be a temporary situation where you've had a stroke and can't communicate. Sometimes people can hear and understand but cannot clearly communicate. It allows you to have someone in place and something in place with your doctor and with other things and with other people so that they know what to do. No one is guessing whether or not you would like to be alive in this condition or whether you would choose to transition. You would be telling them how you want things to go.
An advanced medical directive, or that's what you'd call that, or is that part of the power of attorney?
It's part of a power of attorney. Sometimes they're included with the power of attorney. I know in some states it's almost the same thing. But what you'd be doing with that is letting a doctor know and letting people know what it is you want and how you want things to happen. So, for example, if you have asthma, a lot of people who have asthma may put a do not resuscitate order in place, and people need to respect that. You would put that in an advanced medical directive, and people would understand what it is you wanted, so that when the time came to make a decision, the decision is made according to what you have specified, not according to what the doctor has specified or how your family may feel. It's what you want.
I don't know, though, what I want. I don't know if I'm going to want to be resuscitated, maybe. How do I make that decision?
Those can be difficult decisions to make with anyone. You would make that in consultation with your doctor. You would also make that in consultation with your minister, because people have spiritual lives and spiritual beliefs that need to be respected. And then you will have to sit with yourself and decide, what specifically do I want? If this were to happen, and a lot of times people find it difficult to get over the if this happens kind of thing, what if kind of question. And they don't want to face the what if kind of question. This gives you the power that if the situation happens, that actual what if actually happens, you have an answer for that. Mm-hmm. And that's important for your family to have, so that they know exactly what's supposed to happen according to what you want. It may not be with what they agree, but they can say, this is what I know she would do in this situation because she has written it down in this document.
Everyone should be doing this, but people don't. Why is it not second nature? Is this something that should be taught in school? You know, should it be a course in your senior year of high school, or, freshman year of college? I don't know when you might start it, but how do you get people to understand the importance?
Some people believe that it hastens death, that if you begin to plan, that somehow you are planning for a certain death. But what you are doing is planning for the way that things will go, how you want things to be. And in some families, it's a way to order the families. It's the way to hand the torch over to the next person to say, this is what's supposed to happen, and these are the tools with which they can happen. So whether that is, I'd like the house to stay in the family, because sometimes people don't know that that house has some sentimental value. Mm-hmm. Sometimes people don't understand that this is actually what I want, this particular article. For some people, it's a gun. For some people, it is a painting. For some people, it's a particular set of acreage for farms and things of that nature. And while people may not like them, view them, visit them in this life, people want that to stay in the family. That is the part of what they want to be considered the family heirloom. That's what you have. That's what this family stands upon. Mm-hmm. And the way to communicate that is through an effective estate plan.
Guardianship. What about children?
Guardianship can be a little bit different and a little bit separate. If you have children, young children, the only way to name a guardian for your children is in a will. Now, people think that, hey, I'm just going to go and my husband or my spouse or the child's other parent is going to take them. But they don't think about sometimes we're all in the family going to get something to eat that night and riding in our car, and we have a car accident. The kids are seated in the back and it's a head-on collision. I have 3 live kids and 2 adults that may not. And you need to name a guardian for that. Because what if neither parent is there? Another issue is trust. A lot of families have insurance plans for their families. $1 million insurance plans. Do you want your 18-year-old to get $1 million at 18 with no restrictions? Do you know what's going to happen? Got to buy a Corvette first. Then we'll buy clothes. Then we'll see about education, and after it's all over, we'll get a house, kind of thing. A trust allows you to put somebody in place so that they can raise your children, and a guardianship can raise your children the way that they need to be raised. And a trust gives the money for that. So you can have a person who is the guardian of your children, right? And that's who will raise your children. That doesn't have to be necessarily someone to whom you're related. It should be someone who has your values, someone who's actually going to do what you want done. So if you have become a vegetarian and that's what you want your children to be, grandmother might not be the best choice for that, depending on what her beliefs may be. If you have decided that you want your children to go straight to college and go through and get an education, the family member who believes strongly in trade schools, for instance, may not be the best for that. I'm not saying they're the worst for that, but are those your values? If you have decided to be Christian and someone else has decided to be a different religion and you come from a different religion, how are your children going to be raised in your value system, with your thoughts, with your needs in mind, so that they're raised the way you would have raised them had that opportunity continued for you?
Is there a guide that a person can follow to address each of these areas: wills, trusts, healthcare directives, power of attorney, guardianship? Is there a booklet that I could get my hands on?
There is a booklet. The Missouri Bar puts out a wonderful booklet that describes everything and that tells you what it is. I certainly offer it on my website as well. And it talks to you about what different things are. But in terms of how to do it and whether to do it, that's in consultation with your attorney, because everyone's needs are different. Everyone has a different way they would approach things so that things are ordered in the way that they expect. Just as individual as some people are, their estate plan is going to be as individual as that. It could be that they trust one person with money and they trust another person with decisions. Okay? Could be that they trust the same person with money and decisions. This person may or may not be a family member. There may be a family member over the decisions and a non-family member over the money. It just depends on what makes sense for the life that they live and the way that they want things to continue.
Sounds to me like that's the best way to approach life, understanding what the future will be, whether you're here or you're gone.
Yes. Yes. When you transition, you want things to be a certain way and orderly. Even if you don't transition and you are not able to make a decision, you can rest assured that the decision that you made can be enforced. For instance, if you make an estate plan and your power of attorney is a part of that estate plan, the person needs to make those decisions for you, but those, you can go to court and enforce those. If you just make a verbal understanding between you and your caretaker, there's nothing to give you some legal status, nor give that caretaker legal status. What people have done is give them a courtesy. So the doctor may interact with them because they see you with them all the time, but the doctor does not have to interact with them. It's the same with retirement plans. It's the same with federal opportunities in terms of Social Security, in terms of benefits and beneficiaries, in terms of signing you up for anything. They will give you a courtesy, but they don't have to do anything. With a power of attorney, a valid power of attorney can do that.
And I could get all of this done with one attorney.
Yes. With one attorney can help do all of that, and it's your way that you want things to go.
What's a beneficiary deed?
A beneficiary deed is one of the unique opportunities in Missouri for you to actually pass property to the person to whom you would like to have it without it going through probate. And so what happens is you complete a deed, and you are gifting basically the property to someone, and you have to record it so that when the time comes and the person has a beneficiary deed, they would show a certificate of death, and in some counties, affidavit for a suggestion of death, and then the property can be retitled. The significance of that is it doesn't go through probate. The significance of it not being included in probate is that it's faster and it costs less. Many people want to know how much a probate attorney costs. Those things are a little bit different, and probate is different because it depends on your estate. You control the cost with an estate plan. Okay? The estate controls the cost in a probate situation.
I see. And that is because it could carry on and drag on for some
That is
period?
because you have opted for the state plan, which requires you to go through probate, which requires the court to have a way to pay for that. So the court if you choose not to have a will, the court has an estate plan for you. All of you, most of, if not all of your things will go through probate. It is more expensive. It takes a longer period of time, and things may not go the way that you would have normally wanted them to go. If you put an estate plan in place, it is less expensive. There are ways to avoid certain costs associated with an estate plan, and there are ways that you can get more of what you would like to have done in an orderly fashion. It just depends on you.
It sounds like the Truitt Law Firm has the right approach and is the perfect place to start if you need an estate plan.
We welcome you.